Groot dele van die land was onlangs pers geverf, gewis 'n pragtige prentjie. Ja, ons praat van die pompoms. 'n persplantjie wat volgens wetenskaplikes uiters sleg is vir die omgewing. Lise Roberts het onlangs met Liamé van Westhuizen van die Landbounavorsingsraad hieroor gesels. Hayley van VDT Prokureurs brei ook uit oor die wet op beskerming van persoonlike inligting en hoekom dit selfs vir boere relevant is. Lise Roberts bring ons nou eers op hoogte met die jongste landbounuus.
In today's news, local animal feed company Animate Animal Health has announced that a court case aimed at its salbutamate 10% product was dismissed with costs by the Gauteng Division of the High Court. This comes after the Association of Concerned Professional Animal Consultants challenged the registration of salbutamate 10% as a stock remedy. According to the association, the registrars of fertilizer, farm feeds, agricultural remedies and stock remedies had failed to consider the application for registration properly. Hugo Hutton, the managing director of Animate Animal Health, says the company feels vindicated by the court's decision. The South African Institute of Auctioneers has cautioned against fly-by-night auctioneers who refrain from delivering their goods. New companies are allegedly using social media marketing to encourage buyers to bid or make offers. The Institute fears that buyers in the agricultural industry might be duped into participating in the bidding. There have also been reports of problems associated with the refunding of deposits. Plaas TV will be presenting an in-depth interview on the issue within the next week or so. And the Competition Commission has announced the signing of a memorandum of agreement with Pick n Pay retailers. This comes hot on the heels of the hype around the surging prices of ginger and garlic. This new step confirms that Pick n Pay has capped its gross profit margin for ginger and garlic as essential food items from the period 28 January to 1 April this year. This period may be extended. The Commission hopes to formalize similar agreements with other national retailers. And that's today's news, but don't go away.
Netafim. Grow more with less.
Hierdie plant wat ons dikwels teekom so langs die pad is nou nogal mooi op die oog. Maar volgens wat ek al gehoor het, is dit nie baie goed vir die omgewing nie. Ek gesels vandag met Liamé van Westhuizen van die Landbounavorsingsraad. Liamé, ja, vertel ons bietjie hiervan. Is ek reg as ek sê dit hoort eintlik nie in ons omgewing?
Nee, glad nie. Ek weet hy's verskriklik mooi, maar hy's baie gevaarlik eintlik. As jy nou eintlik dink, hy kom uit Suid-Amerika uit, so dis nie 'n inheemse plant nie. En wat gebeur is, die uitheemse plante kom nou gewoonlik sonder hulle natuurlike vyande in. So hulle populasies word nie gereguleer soos wat normaalweg onder normale omstandighede gereguleer gaan word nie. En by ons het hy nou net vir homself 'n niche gekry en hy het net weggespring en dit is nou hoekom ons sit met hierdie plate pink, veral hierdie tyd van die jaar, ja.
Wat is die botaniese naam?
Dis Campoclinium macrocephalum is die botaniese naam vir hom, ja.
En kom dit oral in Suid-Afrika voor of is daar iets waarvan hierdie plant nou spesifiek hou?
Ongelukkig vir ons is die plant baie goed aangepas. So hy kom oor wyd versprei voor. Sy beperking is maar reënval, maar jy sal hom regdeur Gauteng, Noordwes, Limpopo, Mpumalanga, oral kry, maar in die Wes-Kaap het ons 'n paar uit lokaliteite waar ons weet waar hy voorkom, maar die Wes-Kaap is nog redelik skoon, maar ook KwaZulu-Natal het redelik baie pompom in. So hy's maar reg oor die land.
En is hy seisoengebonde?
Hulle begin gewoonlik so September, Oktober, gaan jy die hergroei begin sien in die veld. En wat dan gebeur is, hier teen April, Mei, begin die hele plant sterf terug. En dan gaan hy ondergronds, en dan wag hy nou weer tot die nuwe seisoen, die somer inkom, en dan begin hy weer hergroei, en dan is die hele siklus net weer aan die gang.
Nou, is julle besig met navorsing oor die plant?
Ja, weet jy, ons deel van die navorsing behels basies meer die biologiese beheer van indringerplante. En spesifiek het ons nou gekyk na pompom, en ons huidiglik ons 2 agente wat in die veld is, wat ons losgelaat het, wat wel help met die beheer van die pompomplant.
Interessant, vertel ons bietjie meer daarvan.
Wel, ek wil miskien net eers sê, dis bedrieglik om te sê beheer en uitwis, want insekte en plante is in 'n equilibrium. So hulle sal nooit, die insek sal bitter selde sy gasheer uitwis. So ons doel met die biologiese beheer is nie uitwissing nie, maar spesifiek in pompom se geval waar jy kry dat hy tot in 'n hektaar kan mens 800 miljoen saad kry as hy 'n volstand het. Ons mikpunt is om te probeer om die saad te verminder. So die insek wat ons het, die blaaspootjie of die thrip soos wat mense dit miskien meer sal ken, is eintlik hy val die blomknoppe en die nuwe groei aan. So hy is eintlik besig om die saadset te verminder. Terwyl die ander agent wat in die veld is, ons het hom nie ingebring nie, ons vermoed hy het saam met die plant ingekom, is 'n plantpatogeen. En hy, veral hierdie tyd van die jaar, kan mens nou sien die plantblaartjies, ek het nou sommer hier vinnig vir jou enetjie gepluk, hy het sulke bruin spikkeltjies op. Nou dit is die plantpatogeen, hy's baie opsigtelik hierdie tyd van die jaar, en hy maak dat die blare, dis nekrose wat gebeur, so die blaar word geel, en dan sterf die blare terug. So dis die 2 agente wat huidiglik in die veld is.
Nou as hierdie beheer nou suksesvol is, hoe lank dink jy kan dit neem voor ons dalk van dit ontslaa raak, of is dit nie in die nabye toekoms nie?
Ek twyfel of ons, ek is versigtig om te sê ontslaa raak, want ons probeer om die huidige infestasies te beperk. So as ons die saadbank, omdat dit so 'n ongelooflike saadbank het, as ons dit kan begin verminder, ons kyk na letterlik periodes van 30, 50, 60 jaar, dit gaan nie in 'n baie vinnige tyd gebeur nie. So is 'n langtermyn projek, dit gaan lank vat, maar die doel ook van biologiese beheer is om saam met ander beheermetodes te gebruik. So ons probeer mik na 'n geïntegreerde beheer plan wat mense kan gebruik om nie net op die biologiese beheer staat te maak nie, dis een komponent, maar ook dan ander metodes by te bring.
Liamé, maar hoekom is dit 'n probleem?
Weet jy wat die groot probleem met die pompom is, hy gaan in die grasland in. En in ons grasveldbioom is beslaan basies 29-30% van Suid-Afrika se oppervlak. So dis 'n groot deel van ons land. En hy is baie goed aangepas omdat sy groeipunt onder die grond sit. So hy sterf in die winter terug, maar sy groeipunt is beskerm. So hy word nie deur ryp of vuur aangetast nie. En wat gebeur omdat hy soveel voedingskrag onder die grond het in sy wortels, kom hulle baie vinnig in die somer oop en hulle druk fisies, die inheemse plante is besig om uitgedruk te word. Ouens met natuurlike veiding, jy is besig om jou draagkrag, want die diere vreet nie regtig aan die pompom nie, so die draagkrag gaan af en baie breëblaar spesies en ook grasspesies word bedreig en letterlik stelselmatig uit die hele graslanddeel uitgedruk. En daar's maar slegs 2% van ons grasveld word aktief bewaar en 30% daarvan is reeds dis onmoontlik om dit weer te herwin. Dit is so beskadig dat ons niks meer weet, jy gaan dit nie weer kan herstel nie. So dit is regtig 'n groot probleem.
Nou het jy raad vir enige iemand wat dalk so iets teekom, dalk 'n boer op sy plaas of iets, is daar iets wat hy onmiddellik kan doen, moet hulle maar met jou in aanraking kom?
Ja, weet jy, die belangrikste is eintlik veral as grondeienaars wat nou kyk, die plant is nou meer opsigtelik omdat hy blom. So as jy gewoonlik nie 'n infestasie het nie, jy is nie gewoond om pompom op jou grond nie en jy sien enkeles, mense moet asseblief proaktief wees. Gaan sny blomknoppe af, grawe die plant uit, want as jy 'n klein infestasie het, is dit nog steeds 'n opsie om fisies die plant te verwyder. As ons begin kyk na waar daar hektaars ingeneem is, dan is fisiese verwydering nie meer 'n opsie nie. Dit is te arbeidsintensief, dit vat te lank, dit is 'n herhaalde proses wat deur die hele seisoen gebeur moet word. Dan sal mense weer moet begin kyk na chemiese beheer en dan biologiese beheer inbring. So mense moet kyk wat gaan aan op hulle grond en probeer om te reageer. As hulle sien die plant is daar en hy was nooit daar nie, haal hom eerder uit. As daar baie van dit is, kan hulle my met liefde kontak. Ons probeer dan mense help om die biologiese beheeragent in die hande te kry dat hulle hom wel kan loslaat om te probeer net om die saadset te verminder.
Nou ja, daar het julle dit. Dit is die pompom en soos Liamé, baie dankie vir jou tyd vandag. Liamé van die Landbou Navorsingsraad gesê het, ons gaan dit probeer beheer, maar ek dink nie ons sal ooit daarvan kan ontslaa raak nie. Ons het vandag nou regtig baie geleer.
Goeiemôre kykers, en vandag se termynmarkverslag waarna gesien word dat mielieskoring sowel as oliesade verlede week swaar getrek het van lewering in Mei. Dit kan gedeeltelik toegeskryf word aan die versterking in die rand die afgelope week. Witmielie se prys is 3.5% al week op week, terwyl geelmielie se prys met 3.3% gedaal het. Koringprys is ook 2.9% laer, terwyl sonneblom en sojaboon onderskeidelik 1.9 en 3.7% af is. Goeie nuus is dat die olieprys week op week met 'n goeie 9.1% gedaal het vir 'n vatjie Brent olie, terwyl die rand versterk het teenoor die vernaamste geldeenhede, 2% sterker teenoor die dollar, 1.9% sterker teenoor die pond en 2.1% sterker teenoor die euro.
NutriFeeds, die formule vir sukses.
South Africa's Protection of Personal Information Act, better known as POPIA or the POPI Act, commenced on 1 July last year, and many organisations are now scrambling to get to grips with what this means for their business activities, their handling of information, and how to go about complying with this law. Joining us today to shed some light on these questions is Associate for FDT Attorney's Commercial Law and Tax Department, Hayley Levey. Hayley, welcome to Farm TV this morning.
Thank you very much for having me, Lisa.
What is this Protection of Personal Information Act, or POPIA as it's commonly known?
All right, so the Protection of Personal Information Act, better known as the POPI Act, is in essence an act that seeks to protect the right to privacy as enshrined in our Constitution. And how it does this is that it places specific obligations on persons who otherwise request, collect, use or process information relating to other persons in order to protect such persons from harm. Furthermore, it establishes penalties in the case of non-compliance. It is established and very similar to the EU data protection law, better known as the General Data Protection Legislation, and is largely similar to the principles as set out therein. So many listeners who might have an organization that operates a global footprint might be equated to GDPR and can rest assured that POPI is largely similar to that piece of law, although there might be some differences.
So what do I need to know, or why do I need to be concerned with applying to this act?
All right, I think the question largely relates to if you should be able to comply with the Act, or do you have to comply with the Act? And in essence, what it boils down to, the general rule is that if you process information in South Africa, you are going to have to comply. What this essentially means is that if you have a business that is located in South Africa, or you have a person who is processing information on your behalf in South Africa, you are going to have to comply. In essence, that means complying with the 8 conditions for lawful processing. Now, if you are a farming business, or if you fall within the agricultural sector, you might be finding, well, this is red tape and I don't want to have to comply. At the end of the day, if you process information of other persons, whether it be your employees or customers, you will have to comply with the provisions.
So who does this act protect?
In essence, it protects both natural persons as well as juristic persons. In the first instance, what we mean by natural persons is living human beings. But by and large, also what many people don't realize is that it protects juristic persons as well, such as companies and legal entities such as partnerships or close corporations or trusts. This is quite radical in terms of our legislator, because they, unlike the GDPR, decided to protect juristic persons, whereas the GDPR only protects individuals. So organizations not only have to comply with the Act, but they can also gain protection from its provisions in the case of persons using information about them in the wrong.
Has POPIA commenced?
POPIA has actually commenced. So it commenced on 1 July 2020, and what many people might not know is that we're in the midst of a 12-month grace period. And what this essentially means is that this is afforded to persons to get their ducks in a row. So come 1st of July 2021, its provisions will be fully effective and as well as its penalties. Now bear in mind that this is not a long period to get your ducks in a row, and that you will want to take the steps necessary to reasonably comply with the Act as soon as possible.
Well, don't go away, stay with us. We are discussing the POPIA Act, and when we come back, we'll talk about penalties. Stay with us. Welcome back. We are discussing the South Africa's Protection of Personal Information Act, which is also known as the POPIA Act. And with me is Hayley Levey. Hayley, what are the penalties for non-compliance?
All right, so POPIA essentially establishes a two-stage penalties threshold. In other words, there are fines as well as imprisonment. The maximum fine that can be imposed is 10 million rand, with a maximum penalty in terms of imprisonment being 10 years. This could also be both. Now, bear in mind that given the severity of the non-compliance, that will largely determine what the penalty will be. However, please also bear in mind that notwithstanding these statutory penalties, the very devastating reputational damage that your organization can suffer, as we've seen in previous months, can largely destroy your organization if you choose not to comply or have mistakes creep in. And then over and above that, nothing precludes any interested person, whether it is the person to whom the information relates, better known as the data subject, or the person who actually is tasked with protecting the information, from approaching a court of law to seek relief and actually claim damages.
Who are the role players?
All right, so POPIA actually establishes many role players. We're going to touch on 3 today. And what's really important here is to bear in mind that given the scenario of processing and your organization, you might wear multiple hats, and therefore you need to actually zoom into the processing activity to find out what hat you're wearing in the circumstances and what role you're playing. So the first person is the data subject. This is, for instance, a customer, a person whose personal information is being processed. So in the context of an example, a business requests that information from the person in order to provide them goods or services. Practically speaking, this could be a farming business who requests information from a customer, who will be the data subject, or an employee in order to process their information in line with their employment contract. The second person is the responsible party. This is ultimately the person who takes accountability of how information must be processed in accordance with POPIA's 8 conditions. This, in the context of our example, would be the farming business, who requests information, and they are then accountable to the regulator, who is POPIA's supervisory authority, as well as the data subject, to ensure that any information that is processed is in line, and they will bear the brunt in the case of something going wrong. The third person is better known as the operator. Now think of it as an IT service provider, or a service level provider, or a vendor, where, for instance, the strict definition is to say this is a person who is contracted in writing on behalf of the responsible party to assist them with the processing of personal data. In other words, they are not accountable to the data subject or the information regulator, but they are tasked in terms of that written mandate. This is really important to understand because it's not them who will take responsibility. They do not share responsibility with the responsible party. In other words, if something goes wrong, the right of recourse that the responsible party may have lies within that written agreement, that service level agreement, or the operator agreement that can be incorporated into that service level agreement at the end of the day. So therefore, if we had to look at the overall supply chain from produce of a farmer all the way up to a retail company to the actual customer, you can see that you could play different role players, and in terms of who you report to, you might be the responsible party, you might be the data subject, you might be the operator. And it's really important to understand what rights, responsibilities and powers you may have in the circumstances in order to effectively roll out what you need to comply.
So within an organization, who takes responsibility for POPIA compliance?
All right, so this is actually quite something that many people are not aware of. The leader or the captain of the ship being the responsible party, is actually a person who is assigned leadership within there, and that person is called the information officer. Now, the information officer has statutory duties and responsibilities to actually guide the responsible party in complying with the Act. They will be tasked with ensuring that that responsible party rolls out a privacy project that in essence is catered for how they process information on the day and ensuring that they meet their obligations. Now, interestingly enough, the information officer is a person that is appointed by default automatically in terms of POPIA, as well as its sister's piece of legislation, PIA, which we won't go into detail today. In the event of a formal appointment not being made, this person is the head of the private or public body. In other words, your CEO. You want to make sure that the person that is appointed or delegated authority, if it's not your CEO, is the right person for the job within your organization. They are going to drive compliance in terms of their delegation, and if they need assistance, because obviously no man is an island, they can have henchmen such as deputy information officers. Very interestingly is that in terms of the draft guidelines that were established last year in July, the information officer is required to be registered with the regulator's office by the 31st of March. Now, those guidelines have not been finalized as yet, and we await further clarification. But importantly, in terms of the most recent notice in February this year, the information officer's responsibilities kick in effectively from the 1st of May. And therefore, you want to ensure that that appointment is finalized as soon as possible, because they are going to drive your compliance project.
Just in closing, Hayley, do you have any advice?
All right. In a nutshell, what's important to realize is that any compliance project requires consideration from an holistic approach, both from a legal perspective of how your company is processing data, as well as its technical systems. At the end of the day, it's a team sport. You need executive sponsorship. And creating awareness amongst your employees is very important, because it's going to eliminate that human risk. Understand and appoint an information officer to drive the project, and seek outside help. There is a plethora of professionals out there that can help you drive your compliance project within reason and what is suited to your business. You do not want to reinvent the wheel, because you did not get into your business to comply with red tape. So understand the landscape and go from there. We are less than 4 months away from the effective date, and therefore act now better than later.
Hayley, thank you very much, and remember the D-Day is 1 July, so get your necessary people appointed, and for any help, of course, there are legal professionals out there to help you with the South African Protection of Personal Information Act.